Rhonda Temple, Lawn Pinnell, Realtor, Interior Designer, and Stager, and I'm here today to interview Kirsten Howe of Absolute Trust Counsel here in Walnut Creek.
Hi, Kirsten.
Hi, Rhonda.
Thanks for joining me today.
Oh, well, thank you for inviting me.
Today we're going to be talking about estate planning and the proper things you need to have in place to protect your most important assets. My first question for Kirsten is, what are the core planning documents that everyone should have?
Well, everyone should have documents to plan for their incapacity. So we want to make sure everyone has a durable power of attorney, and that is a document where you would designate someone who can do legal and financial things for you if you become incapacitated. The other incapacity document that we want everyone to have is a health care directive. That's, again, a document where you designate someone else who can make medical decisions for you. And then everyone needs a will. And the will tells us who gets your assets when you die and who will execute your will, who will administer your estate. It's very, very common to use a trust in addition to the documents that we just talked about. So a trust allows us to avoid probate court. A trust will do all of the things that a will does, but it does it privately rather than in a courtroom. The first question is, what is the value of the assets in the estate? And once they are approaching $150,000, then we really start to think maybe a trust is appropriate, and especially if the client owns any real estate.
So what kinds of things should be in a trust?
Most of your assets belong in your trust. So your real estate, your home, your rental properties, bank accounts, investment accounts, stocks, bonds. We even tell people to make their trust be the beneficiary of life insurance. Really, the only assets that we don't want in the trust are the retirement assets, such as IRAs and 401ks. Those are pre-tax dollars, so we don't want to mess around with their tax status by putting them in the trust.
So once you set up your trust, how often should people be reviewing that with their legal counsel?
Any change in your life that is significant might cause you to need to update your estate plan. Someone in the family gets divorced, or a new grandchild comes along, or a new child, or someone gets married, somebody dies. Even if nothing like that happens, I tell my clients, get your estate plan out of that drawer every 3 or 4 years and just read the important parts and make sure it still makes sense to you.
Who's the most appropriate person to choose as your executor or your trustee?
The most important thing is to pick somebody who you trust, who has a sense of duty, a sense of obligation, who if you give them a job, they'll get it done. There are professional fiduciaries, meaning they act as a trustee or executor for people who aren't family members, and they do it for a fee.
How much does it cost to set up a trust and do all of your estate planning documents?
It depends on the complexity of the estate. A single person will be less expensive than a married couple. People with lots of assets, unusual assets, that's more expensive. And the family situation, so a blended family where there are stepchildren, the things that make things complicated, most people can probably do that comprehensive estate plan with a qualified attorney for somewhere between $2,500 and $5,000.
So what is the most important thing to be concerned about when titling your property?
Probably the most important consideration when you are taking title, especially to real estate, is what would you want to happen if one of the co-owners were to pass away? There are a number of ways that two people can own property together. They can own it as joint tenants, and what joint tenancy means is if one of the owners dies, the other one owns the property. They don't need a trust, they don't need a will, they don't need to go to court, they just automatically own it. If you don't say joint tenants, the default is tenants in common, and that means each owner owns their share, and they can leave it to whomever they wish in their will or in their trust. So it's important to think through what you would like to happen if you passed away.
The cocktail I've chosen for today's video is called the Attorney Privilege, and it consists of 2 ounces of bourbon, half an ounce of orgeat syrup, and 2 drops of bitters. And we're going to have one right now. Here's our attorney privilege for our attorney, Kirsten Howe of Absolute Trust Counsel. And I'm so glad you were here today to answer these very important questions. Thank you for all your help.
Thank you, Rhonda.